Would you be seated?
Yes, my apologies. I had to attend to regional court matters before. We can proceed.
Worship, today is 7 August 2025 in the Magistrates Court, sitting at JP Karawai Street in the matter between the state and Emmanuel Mulunga and 14 others, case number 854 of 2025. Presiding officer, Mr. Samunzala, for the state, Mildi Lungwe, for accused 1 and 3, Mr. Bangamavo, accused 2 and 14, Mr. Isaacs, and I see Mr. Cupida is here, standing in for Mr. Isaacs, accused 5, 6, 7, and 10, Mr. Namanje, accused 4, Mr. Kasper, and accused 9 and 15, Ms. Gebhardt. And we are ready to proceed.
Morning, worship. Please go to worship. I still appear on behalf of accused number 1, fourth and fifth applicant. Please go to worship.
May you please record Bishop I continue appealing on behalf of accused number 4.
Worship, may it please the court appear for accused 9, applicant number 7 in the bail proceedings. As it pleases the court.
Please go to Bishop I still appear for accused 2.
As the court pleases, Your Worship, may I continue with cross-examination?
You can proceed.
Now, if the witness could be given exhibit D1. D1, I'm not too sure whether it's part of those other bundle. D1, in particular at page 271. Check if there is D1. Yes.
What page?
271, Your Worship.
But D1 ends at 1.
It's on a continuation, Your Worship, I think. It's a continuation. Two seven.
Say, are you there? 271.
I'm there, Your Worship.
Now, yesterday, you remember that is the internal memo by Olivia Dunaiski to Emmanuel Murunga. You spoke about it in your evidence in chief.
That's correct.
And in one of your statements that you made when you were being led in evidence in chief, you said this initiated the, if I understood you, the criminal activities. Or did I get you wrong?
Definitely you got me wrong.
Or what did you say? What did it initiate? You did use the word initiate.
Initiated, or rather subsequent to this document,
Subsequent to that document?
the commercial offer was given to Namcor, to Enacon by Namcor.
Okay. Oh, that is even better. So it did not initiate criminal activities, as you confirmed now.
Not entirely correct. In fact, totally incorrect. We are having charges of conspiracy. And we know that in my examination in chief, I indicated that as far as the evidence we are having is concerned, the acquisition of the assets started already by May. In fact, in my examination in chief, I indicated the 10th of May. That is the earliest records that we have.
There you start with answering something I didn't ask. I started off saying, did I understand you correctly that you suggested criminal activity started with this document? You corrected me and said, no, it is what happened subsequently. Now, when I said, okay, it's even better if it did not start criminal activity, you start changing your version. What is what?
Criminal activities, especially of conspiracy, could have well started even before the 10th of May 2022, because the records that we have in terms of evidence just cemented the discussions that could have taken place. So your question was specifically if the criminal activities were initiated after this.
Yeah, but I never said after that. Today, don't misquote me. Today I never said, I said, did you not say this document initiated criminal activities? I did not use the word after. You must listen to the questions, please. Okay, so what was initiated by this document? Just for clarity. You used the word initiate yesterday.
I've answered it already. I said the commercial offer.
Okay, good. Now, this document, Mr. Peter Elindi and Malakia Elindi both stated that, first of all, they were not aware of its preparation because it's in an internal document and they have nothing to do with its preparation. What is your comment, if any, in that aspect? That is evidence they gave. Do you have any comment or you do not have?
I was waiting for you to be done with your phone so that you pay attention to my response. Although they may not have been aware of the production of this document, they were aware of the undertakings because the planning of the activity started even before 10 May 2022.
Sir, I'm not asking that. My client stated they did not have knowledge of preparation of this document. Do you have evidence that they have had knowledge of the preparation of this document? Do you have such evidence?
When the evaluation was conducted already before this document was produced, Nacon's representative accompanied Namcor's engineering team. So even if they were not instrumental in the creating of this document, they were well aware of it.
Listen to the questions. I'm not asking, you said the engineering team was accompanied by a certain Thomas, what is the name of the person you said?
Matthew Iambo.
Yeah, Matthew Iambo. I'm speaking about Peter Elindi and Malakia Elindi. Do you have evidence that they knew that this document is being prepared? I'm asking for evidence. Do you have?
It's common cause if an entity sends its employees out, that employee need to be authorized to go and do that.
I'm not asking about that. Do you have evidence about this document?
I've answered your question, Mr. Namanje.
No. You are not answering the question, please. You are not answering the question. If you do not want to answer, then you must say, listen, wait until I speak. The question is very specific. This document was prepared on the 8th of July, 2022. You see that?
That's correct.
Let's start with Mr. Malakia Elindi. You are the investigating officer. Did you collect any evidence showing that he has personal knowledge that there is an internal memo dated on the 8th of July addressed to the managing director by Ms. Olivia Dunaiski? Do you have such evidence in your docket?
I've answered your question and I will repeat again. I said, although they were not involved in the production of these documentations, they were well aware of the engagements, because by May, we have already demonstrated evidence that by May already, the undertakings for the acquisition had already commenced.
No.
So this was an internal process. Of course, they were not involved in the document, but they were aware.
Aware of what? Of the document.
Not of the document.
Okay, that's what I wanted. So they were that. Why did you take long to answer? So your answer is that they were not aware of the document. Let's move to the one paragraph in the document. Now, go to the next page. Read the first paragraph.
Additionally, Namcor would like to become the preferred supplier to the Ministry of Defense in the long run, and through acquiring these assets, it will put Namcor in a favorable position for future business relationship with the Ministry of Defense.
Mr. Murunga confirmed there's nothing wrong with that. That yes, this was a strategic policy decision, a commercial decision. Do you have any comment?
Yes, Your Worship. I have a comment.
Yes.
When I read this paragraph,
Yes.
we can divide it in two folds. The first part of the paragraph says, additionally, Namcor would like to become the preferred supplier to the Ministry of Defense in a long run. That is number one, meaning the intention of Namcor was in a long run to become a preferred supplier of petroleum products to the Ministry of Defense.
Yes.
Now, the second part, through acquiring these assets, it will put Namcor in a favorable position for future business. So, meaning, through acquiring meaning buying and purchasing the assets
Yes.
that they wanted to buy.
Yes.
I've answered.
That is what he said.
Yes.
Yes. So you agree with him. Then go to the next paragraph and read it out.
The feasibility study results were favorable in acquiring the assets of Namcor Namibia worth 53,212,000 Namibian dollars.
Okay, just end there. Do you know what feasibility study is being spoken about?
The discounted cash flow.
Okay. Do you know what is a discounted cash flow?
I've seen the document during the investigations. I have sought explanation as to what was the intention of the report.
No, but I'm asking generally.
Yes.
By training, do you know what is it?
Of course.
Okay. Go to page 243. Or same document, 243, Your Worship. Now, in your docket, are you in possession of the document from page 243, Your Worship, to page 263? In your in your ACC docket for this case, do you have this document?
Yes, I do.
Okay. Who prepared it?
The document was prepared by a financial analyst employed by Namcor. His name is Sam Hashela.
Sam?
Hashela.
Okay. What did you ask? What qualification he has?
Your Worship, I don't think I've asked what qualification he has, but we have gone as far as asking what experience he had,
Yes.
how long he's been working for Namcor, what his responsibilities were, and so forth and so on.
Okay, that is the man that gave a favorable feasibility study on the basis of which it was recorded by Ms. Dunaiski that the feasibility study was favorable. Is that correct?
That's correct.
Now, just comment, my clients were not involved. Peter Erindi and Maraki Erindi were not involved in this feasibility study.
Definitely they were not.
Okay. So it is an internal process to determine whether it is worth buying and acquiring the assets of Namcor. Do you agree with me?
I agree with you that it was a feasibility study with determining the viability of the buying of the assets.
Yes.
Thank you very
And
much.
it was favorable.
Yes.
In other words, the person the professional who prepared it, gave it a go-ahead, so to say.
Definitely.
Okay. And this was necessary so that the department concerned could then make a recommendation to the MD. It is very clear from the document.
That's correct.
Okay. Now, you have been talking about planning and arrangement and undertaking and criminal activities. Of course, you have been contradicting yourself. I will come to that. But was this part of the criminal activities you referred to, this document preparation, or this one is something else? Is a clean, legitimate, no criminal activities involved?
Your Worship, this is an instruction which was given to a staff member. Based on the variables that were provided, the report was generated.
Yes, no, I'm just asking. So I just want to be sure. Is it part of criminal activities, the activities of Mr. Hashera preparing this document? Is it part of criminal activities based on your investigation?
Based on the investigation, this is part of the documentations that was used to create a misrepresentation.
Create a misrepresentation by who?
By who?
Yes.
We have been talking about one misrepresentation that was done all along.
No. Listen to the question. A document prepared so that somebody could make misrepresentation. Who used this document to make misrepresentation?
The requester of the document.
Okay. Making misrepresentation to whom?
Mr. Namanje, the ultimate misrepresentation happened when the contract was signed. Meaning some of the sub-processes that were followed, when a subordinate is requested, for example, when Sam Hashela is requested by Cedric Velemse, not Cedric Velemse, Your Worship, Mr. Velemse and Mr. Dunaski to prepare the report. This is a staff member that is preparing a report and he's given the information.
Oh. Say, are you serious?
May I just rise and say, I'm not aware of a Mr. Dunaski in this call. You heard the witness saying Mr. Dunaski, Worship, so I'm sure he's referring to a Mr.
I'm referring to Ms. Dunaski.
Yes, can I proceed?
You can proceed.
Let me. I'm saying, are you being serious when you testify now? And you are confusing me as a lawyer. You said this document was prepared so that a misrepresentation is made. This is as far as Namcor is concerned, because it's a Namcor document. I just want to understand you. Is that what you are saying?
Your Worship, I think I've been serious since I came in this court. I've been serious from the moment I was assigned the investigations for me to investigate.
Just answer the question, please.
So, but at least we need to remove the statement as to whether I am serious or not.
Answer the question.
The document was prepared to make projections as to whether the undertakings were feasible whether it was feasible for Namcor to acquire the assets, and it was done.
Yes, but you are not answering the question. I want to understand it was prepared so that a misrepresentation is made. This is a Namcor document. I just want to who at Namcor was going to make a misrepresentation as an individual with this document? Is it Mr. Hashera?
This document was not used alone. It was used together with other documents, which at the end of the day resulted into the agreement to be signed.
Fine.
And when the agreement was signed, that's when the misrepresentation occurred.
Okay, but if it was used, this document was never, do you accept that this document was never ever offered to anybody, given to anybody by my clients, the two Elindi brothers? Was never. They never communicated this document ever to anybody. Do you accept that?
I accept that.
Okay. So if they have never offered it, if they have never communicated it or passed it to anybody, they will never have used it to make misrepresentation to anybody, both in terms of a matter of practicality and in law.
Your client has not been charged for fraud in respect of this document.
Okay, good. Let me move. So then, this is maybe some internal fraud we are talking about.
That is why there's fraud in respect of the staff members, is because there was a misrepresentation towards their employers.
Okay, fine. But the document on its own, Mr. Hashera did his work professionally, legitimately. The document in its own, it's legit. It's fine. There's nothing wrong with it.
I believe so.
How can you believe so, Mr. Inambao? Turn to page 17 of the same document. Your Worship, I do not know whether my colleague Advocate Lilungwe gave the witness also the first part of the bundle, D1. Let's just make sure that the witness also have D1.
Yeah, D1. That's
From J1.
Yes.
Page 17, the second amended particulars of claim. Now, are you aware of a civil case instituted by Namcor, the holding company, and Namcor Trading against a number of persons, including my clients? Civil case.
I'm aware of it.
Did you ever read those documents as an investigating officer? Particularly the particulars of claim.
Your Worship, I have been busy conducting criminal investigations, and we have been busy gathering investigations so that we wrap up the investigations. So I never had the opportunity of reading this document.
Okay. So then the answer is that you were aware, but because you are still busy, you never got time to read the particulars of claim.
I didn't read the particulars of
Okay.
claim. I believe I answered that question already.
Okay, let me surprise you. If you can go to page 22. 22. Now, can you read paragraph 22 at page 22, your Worship? Paragraph 22, read it.
The purported recommendations by the 8th defendant
And just for your information, Mr. Inambawa, so that I'm fair to you, the 8th defendant being referred to in the particulars of claim, Your Worship, at page 18 is Ms. Dunaiski. Just for your information, so that proceed.
The purported recommendations by the 8th defendant and purportedly supported by the 9th defendant.
Just hang on there, so that, because you said you haven't read it, the 9th defendant, Mr. Inambao, Your Worship, at page 18, is one Davis Mafosa. Yes, go on.
and approved by the fifth defendant.
And the fifth defendant is Mr. Murunga at page 18, Your Worship, for your notes. Yes, go on.
Also followed upon a project feasibility study by a certain Mr. Hashela, the financial analyst employed by the second plaintiff, and which was based on the discounted cash flow DCF analysis. The DCF analysis was not appropriate in the circumstances because.
Yes, okay. Now, the particulars you haven't read. Now, this work by the Mr. Hashera has been criticized in this particulars of claim as just a sham process, according to Namcor. Are you aware of that? In other words, Namcor has told a different court in the buildings neighboring this court that this work by Mr. Hashera was not appropriate and it was criticized and so forth as part of a sham process. So is this the first time you are hearing it?
It's not the first time I'm hearing,
Yeah.
but I don't think I should be able to comment on what happened in the civil court. I should be able to comment on the evidence that I've testified on or the evidence that we have gathered during the criminal investigation.
No.
Besides, the burden of proof in the two matters is totally different.
No. Don't go to the burden of proof. It will be dangerous there. All I'm trying to say is that, do you trust Namcor? Because Namcor appeared to reconstruct its version whenever it suits it. In a different court, it relies on the same agreement and accuse employees of creating sham documents, including the evaluation.
Your Worship, as to whether I trust Namcor or not, I am looking at the pieces of evidence that we have gathered during the investigations.
Okay.
There was no point that Namcor had, didn't say it was sham. Even in the complainant statement, he did say so.
In the complainant statement, what happened?
I'm saying, even when the incident was reported,
Yes.
that was said.
Oh, so who said that?
I testified in the examination in chief as to who reported the case.
No, just state, please. When I
Mr.
asked-
Kongoro.
Yes. So he accused who? Mr. Hashera,
Well, he accused the whole process.
including Mr. Hashera.
Mr. Namanje, don't put words in my mouth.
No, you are saying, please.
No, he said it was a sham report.
Okay, the one prepared by Mr. Hashera.
Yes, we know it was prepared by Mr. Hashera.
Okay, so then he made allegations of being part of the fraud against Mr. Hashera. Remember, we don't have that statement. You have it.
Yes. Mr. Namanje, I don't know why we are going there.
No. Answer the question. Did Mr. Kongoro accuse Mr. Hashera of being part of sham process, fraudulent process?
Yes, he did.
Okay. So there are more people accused of fraud in relation to this matter at Namcor.
I suppose you know that, Mr. Namanje, when I testified in the examination in chief, I said part of the outstanding processes is to secure other suspects who are not yet before this court.
Okay. So, but they were accused in the same manner, in the same document. You pick and choose some.
Not necessarily. Mr. Namanje, a person can say you are a suspect. The investigations need to yield evidence indicating and proving that indeed this person has committed an offense.
Okay.
So it's not that we basically just pick up every person because somebody has said this person is a suspect. It needs to be guided by pieces of evidence.
Okay, you doubt the allegations by Mr. Kongoro that Mr. Hashera was involved in fraud.
It's not doubting. Mr. Kongoro is not an investigator. ACC investigate each allegation and based on the evidence that we establish, that we find, then, charges would be instituted based on the amount of evidence that was gathered.
But there is still public interest then, in relation to this matter.
Of course.
Okay.
I mean,
People
that
can
is,
get bail.
that is why we are here. There's still it's because of public interest.
Okay, fine. Let me address another matter. Did Mr. Kongoro also accused Davis Mapotsa, who is sued in the civil case? He's a defendant.
Your Worship, I don't know why I must be answering questions of a matter that was dealt in the High Court in the civil case. Your Worship, I'm supposed to be answering evidence pertaining to Mr. Namanje's client and them being released to bail, or on the pieces of evidence that I've put before this court.
No. I'm asking about this case actually, because remember you have been making loose statement yesterday of my client involved in the planning and conspiracy. No, I'm asking about people that worked on this very matter. So all I want to know is, did Mr. Kongoro also accuse David Maposa, so that I can be specific about Mr. Peter Erindian? Did he do that?
Mr. Namanje, as it's indicated here, you can see there's a lot of plaintiffs. But my response would always be the same. Anybody can come and say this person has committed an offense, but we need to find evidence in order to arrest this person. Besides, we have just indicated before this court that the matter is still under investigations.
Okay, no, but I'm not asking.
So I don't know why, Mr. Namanje, you want me to be able to confirm to you as to who is the person that is listed as a suspect and not. You are actually trying to compromise my investigations here.
Your Worship, I find what is happening here very disconcerting. Your Worship, this witness must be called to order.
Yes.
You can see the witness demeanor. Look at his face there, Your Worship. Why is he angry? Why is he frowning? He's here as a witness to this court, Your Worship, not because we want him here. He should simply answer questions posted to him. And Your Worship, this is cross-examination. The witness cannot decide which questions he will be asked, which questions are relevant. It is for this court, Your Worship, to order where there is an issue of irrelevancy. This court will step up and order that, well, this is irrelevant, you cannot answer. But Your Worship, this has gone on for far too long. This witness must be called to order.
Just to add, Your Worship, you remember, Your Worship, when my clients were testifying, applicants, a number of times the court did caution them that when my colleague was, that they must answer questions. I think the same must happen with this witness.
Yes.
I'm doing what I have taken an oath to do, and I need to do my work.
Your Worship, it is very clear. I think even the tone of Mr. Namanje, sometimes he screams at the witness, but there is no issue with regard to that. I think that's how the witness is answering. So he cannot be said that he is frowning. If that was the issue, I think the court would have raised it. I think going forward, if there is an issue, it must be addressed right there and then. So I do not think the witness is angry. Perhaps it's just the manner in which he's answering, and he's answering questions that have been put to him. And I think in all fairness, the witness is here in a bail hearing, not to comment on cases that relate to a case in the civil court. We are not in the civil court. I think everyone else is well aware of that.
Your Worship, with greatest respect, this is one and the same thing. I'm entitled to take the witness to any document that is part of the civil case is part of the exhibit handed up here. My colleague did not object. How can I not ask the witness about document handed up as exhibit? Why were they handed up? Your Worship, just like our clients, the witness must answer questions.
The court have not seen the witness frowning. Yes, for the record, I have not seen him frowning. He does not appear to be angry to court. He's simply responding to the questions. Now the witness is on record. Mr. Namanje, you are putting questions. If, for example, he is not answering your question the way you want it, we have already indicated that is his answer and we are on record. You direct him, my question has not been answered, I move on. But that is his answer. The court cannot tell him, or we cannot tell him to answer what you want. He is responding as he deems fit. And we are on record.
No, I think, Your Worship, you, with respect, you misunderstood the complaint. The complaint is not that he must give the answers counsel is seeking. What he cannot do, he cannot avoid answering a question asked. If he cannot answer, then he can say he cannot answer. Your Worship is different. A witness must answer the question asked. But he cannot try and answer something else and say, I have answered. There's a difference, Your Worship. Our complaint relates to the fact that he must address the question asked. Those are two different things. So if I ask a question and he starts answering something else, it's your duty, your Worship, with greatest respect, to direct the witness to attend to the question being asked by counsel. Otherwise, there will not be justice. So it's two different things. A witness has no freedom, has no liberty to answer everything he thinks is nice to say. He got to answer. I don't care whether the question is bad or good, but he must answer the question unless it is my question is objectionable. But
But I hear the witness. The witness is responding to your answer. So if he is not responding to the answer you posed to him, put it to him. That is not the answer. That is not my question.
Exactly.
My question is like this. Yes.
Okay. Let's go on. Let's monitor that. Let's monitor that. I'll continue. I'll continue monitoring.
So if he has not responded, say, please, that was not my question.
Okay.
My question is this one. Do you have an answer to that question or not? So that we can.
That's a good ruling. A good ruling. Listen, sir. Please listen carefully to my questions and only answer my questions. I start again on this question.
Sir, you are informed. Answer the question. If you have no answer, simply indicate I have no answer or comment so that we can move on.
Go to this question again. You talked about the complaint, Mr. Kongoro. All I want to know, did he accuse this 9th defendant in the civil case, Davis Mafosa? Did he accuse him of being part of the fraudulent activities?
No comment.
Okay, I want to just give you a benefit, but it's up to you. I'm not forcing you. Is there a reason why you are not commenting on? Do you have any fear?
Mr. Namanje, whether you like the answer which I have given you or not, I've just answered you. You wanted an answer?
Move on. Yes, Mr. Namanje, we move on. Your answer is answered.
Now let's go back to to another document. We move to, Your Worship, back to page that deals with the Mr. Hashera's document. Now, do you know that Mr. Hashera determined that within 4 years of the asset purchase agreement, Namcor, according to his projections, would have recovered the purchase price by exclusively supplying petroleum products to Enecon, so that Enecon then supplied Ministry of Defense through those assets. Are you aware that the feasibility study, according to the document and Mr. Murunga's evidence, within 4 years, the projections are that the 53 million would have been recovered. Any comment on that?
Your Worship, and I want to make sure that I answer you correctly, because your question, the first question, was in two folds.
Okay.
You said in the supply of fuel at the end. The feasibility study was aimed at, you are correct that it was aimed at establishing as to whether the project is feasible or not.
Yes.
And in terms of the study, Namcor Trading could recoup its investment in 4 years.
Yes.
But it was not aimed at the supply of fuel. It was aimed at purchasing the assets.
What are you trying to? You are contradicting yourself.
And hence I said, because you mentioned the supply of fuel, and I want to make sure that I'm also clear that when I'm giving you the response, it's not that I'm agreeing that it was to the supply of fuel.
No. Let me go over. The feasibility study found that Namcor will be able to recoup and recover 53 million it paid to Enecon within 4 years. Yes or no?
Yes.
Okay. The feasibility also found that the remaining period would for it then to make profit.
Correct.
In addition to recovering the purchase price.
Yes, correct. On the assets that they were buying, not on the supply of fuel.
Oh no. Look, what do you mean on how do you make profit on the asset you buy? What do you mean?
Your Worship, we have just read the internal memo of, you made me to read the internal memo of Ms. Dunaiski. It was talking about the purchase of the assets. The feasibility study was in regards to the purchase of the assets.
Yes, we are on the same page.
Thank you.
But I'm saying, when you how was Namco going to recoup 53 million? Is it not to supply Enecon exclusively, that no other supplier will supply Enecon? It will then recover 53 million. That is what the report is saying. That is what Mr. Murunga stated. And that is what the asset purchase agreement is saying. I will take you to the agreement.
Your Worship, the transaction happened on the 18th of July.
I'm not asking about it.
And just allow me to just give you an answer. It happened on the 18th of July.
Yes.
This, Mr. Mulunga left the office by April when he was suspended.
Yes.
Until then, Namcor never got anything. So how were they going to get anything in the end?
What do you mean Namcor never got anything? What do you mean? What are you trying to suggest? When you say Namcor never got anything, it got anything. It sold products to Enecon according to the asset purchase agreement, and I will show you.
That's what you are saying.
Okay, I will go to the agreement later. Let's go on. Let's go to the valuation of assets. In your docket, you have the valuation of assets.
That's right.
Who did the valuation of assets?
Nesta Shefeni and Michael Ipanda.
Okay. According to your investigation, did they carry out their professional duties legitimately, ethically, without involving themselves in the...
Your Worship, I have to object to that question. It goes down to the issue of relevance. How relevant is that question with regard to the issue here? I do not think we are busy with the issue of valuation of assets here.
Oh,
it's not relevant.
Oh, Your Worship, with greatest, do I even need to respond to that? The valuation of asset is the center of this matter. Even my colleague led cross-examined to my client on the same issue. How stingy is he? He could ask my witness on the valuation, but he does not want me to ask questions on the valuation. Can I proceed, Your Worship?
Yes, this aspect has been dealt with. The court will overrule the objection. You can proceed.
Let me just say why I'm asking those questions. Remember, in the charge sheet, my clients are not alleged to have conspired with Mr. Murunga. I showed you yesterday.
You were asking the question. I thought you were repeating the question so I can answer it for you.
No, I'm trying to make it clear to you. Please just listen to the question.
Sure.
You remember yesterday I took you to the charge sheets against my client, and I showed you that as far as these charges are concerned, my clients are not charged with conspiring with Mr. Murunga. You remember yesterday?
I hear you. Yeah, I remember.
Okay. But at some point you made general statement that my clients must have been involved with employees of Namcor. You made such a statement yesterday. Oh, I misunderstood you.
Well, we are on record right now.
You are not
I
sure.
can hear what you are saying, but just proceed.
Okay, fine. I just want to check something with you. The valuation by Chair Feni and is it Mr. Haipanda?
That's right.
As far as you are concerned, is it a fraudulent document or it's not a fraudulent document? As far you said,
As far as I'm concerned,
yeah.
the individuals had visited the sites in question. They did what they went to do there and provided a report.
Yes.
So for me to say whether it's fraudulent or not, it's not something that I can say because the people went to the sites.
Okay.
They saw the sites, they took measurements, and after that they produced a report which was brought to management.
No. I think you misunderstood me, Mr. Inamba. I'm not saying say that it is fraudulent. I'm asking whether, from your perspective as an investigating officer, it is a fraudulent valuation. I'm not saying say it is
No.
I think he has answered. He said he cannot say.
Oh, okay.
fraud.
Yeah, exactly.
Yes, we can move on.
And now, if you cannot say that, am I correct to say the amount that was offered by Namcor to my clients for the asset was determined exclusively, internally, properly, and legitimately by Namcor?
That's correct.
Okay, good. Now, let's then go to the agreement and show you that Namcor did get something, and Mr. Mulunga's evidence as to what was contemplated in the agreement is very correct. Let's go to the asset purchase agreement, Your Worship, at page 50. Page 50. '51. Are you there, Mr. Inambao?
I'm there.
Now, just listen to it so that you understand where I'm coming. Are you aware that the two public prosecutors in this court have suggested that Namcor did not get ownership of the assets? Are you aware of that?
I'm aware.
Okay. They have also suggested that Enecon ought to have stopped using the assets, the pumps, the tanks, so that Namcor take over. Their cross-examination of my client suggested that they misunderstood that Enecon ought to have walked away with the 53 million and Namcor would have started directly supplying the ministry. Are you aware of that?
I'm aware.
Are you the one responsible of that understanding by the prosecutors? Are you the one that suggested that to the prosecutors?
Investigations was conducted.
Yes.
Evidence was presented to the prosecutors.
Yes.
So that understanding comes from the evidence that was gathered.
Is that the evidence you gathered that Enecon, once the agreement is signed, Enecon would have walked away, Namcor would have taken over the pumps and directly supplied the ministry? Is that what you have gathered with your investigation?
The evidence gathered shows that Enecon was buying the physical assets. The physical assets that were evaluated by the engineering team.
Yes.
So that is the understanding.
Namcor was going to buy right, interest, and title in the asset as appear in the asset register and in the valuation.
No, that is misleading. And I'm saying it's misleading because Namcor was buying the assets. They were not buying the rights. And that is what that's what stands on the commercial offer, and that's what stands in the contract.
I pity you. Can you buy asset without buying the related rights.
Well, the rights, of course, if you buy the assets, they become yours.
Yes, that's what I'm saying. So they bought the title, right, and interest in the assets.
No. When you are saying in the assets, you are excluding the physical assets.
Who said that? I never said that.
You just said in the assets.
Yes, that's what the agreement is saying.
Okay, I hear you. It appears that you are in agreement. Yes.
Yes,
we can move on.
let's start at to show now, and this is with greatest respect, very, very concerning, that a distortion was put to my client by the public prosecutor using something apparently you gathered. Let's start. Let's start at the top.
Your Worship, I have to object to that line of question. I think you can just put questions without actually putting blame on me or disrespecting me in a polite but rude manner, because I can also do that. I can reciprocate.
No. But, Your Worship, I never suggested any dishonest on the part of my colleague. I said prosecutors asked questions that are distortion because of what he gathered. And I will demonstrate that that was a distortion. I'm entitled to say that.
Can you put the question?
Yes. Let's start on the at page 51. At page 51, first of all, do you know a principle called parole evidence rule?
Your Worship, I'm not a lawyer. I am an investigating officer, and I think I've indicated that yesterday.
No, I just asked if you
No.
know. Okay. Now, do you see that the agreement on the face of it, it says that the managing director was jury authorized?
That's correct.
Okay, that's what the agreement is saying. Then over the page, let's go to page 52. If you can read the second paragraph, which starts with whereas Enecon.
Okay. Whereas Enacon is the owner of certain bulk storage facilities comprising those assets and any and all equipment used by Enacon in conjunction with the operations of the said asset set forth in Exhibit B attached hereto,
Yes.
herein after referred to as the assets.
Okay, now, first of all, it's common cause that this positive assertion that Enecon is the owner, this is drafting work, authoring work by Namcor Legal Department, is that correct?
That's correct.
And the legal department must have worked with the team of Namcor that visited the sites where the assets are.
That's correct.
Okay? So in other words, it must be taken that Namcor, through its investigation team, the team that evaluated the asset and the legal department, to draft and author this part, they must have familiarized themselves with the ownership state of the asset.
Your Worship, I believe that was the purpose of the feasibility study that we, feasibility report that was presented, and as well as the evaluation report.
Okay.
So the legal team would have had access to this documentation.
Yeah, hence they said Enecon is the owner of the asset. Then let's move on to the next paragraph, the third one.
Whereas Enacon desires to sell, transfer, and assign to Namcor Trading all of its rights, titles, and interests, and to those assets as set out in Exhibit B, and any and all equipment used by Enacon in conjunction with the operation of the said assets and located on the premises set out in Exhibit B.
Okay, now, remember now, we were talking about right in the assets and so forth. Now, if you can just read out paragraph 1.1.
1.1.
Yes, that is the very important paragraph, what is being sold. If you can just read out for the record.
1.1. purchase and sell.
Yeah.
On and subject to the terms and conditions of the agreement, Namcor Trading agrees to purchase from Enacon, and Enacon agrees to sell and transfer to Namcor Trading all of Enacon's rights.
Yeah, okay, just park here. Enacons, the first one, right? Do you agree with me?
Yes.
And what is the second?
Title
That is number 2.
and interest.
Yes. What is the word that is next?
In and to the assets.
Yes, that is. Remember our debate before this?
I remember,
I
but
took
you
it from the agreement.
yes, but you omitted to read the first part.
Okay, no, it's fine.
Because if we go back to the first part, you would see what is it that Namcor was offering to buy.
Okay, but we don't need to debate it. It's written there. Okay?
No. I believe what is written there, it's what is in the commercial offer that was provided.
No, it's fine.
Yes, but you are in agreement. I don't. Yes. With regard
To what is
rights,
written.
title and assets.
Yes, Josh.
Yes. So we can move on.
Yes. Now, then, I want you to then go to the. I'm starting now to show the distortion I spoke about that you caused public prosecutor to put to my client that Enacon would have walked away. And that is, I'll start doing that at page 55, Your Worship, and this is very important. Can you read the heading under clause 3?
Utilization of Namcor Trading assets for storage of petroleum products.
Okay, that heading tells you Namcor assets, and those are the assets it will buy from Enacon, will be utilized, but it doesn't tell you for now in the heading who is to utilize it. You agree with me?
I agree.
The answer is coming in the next paragraph. Read paragraph 3.1.
Following the transfer of ownership of the assets to Namcor Trading pursuant to this agreement, Namcor Trading hereby authorizes Enacon to utilize and store only the petroleum products procured from Namcor Trading for the duration of the supply agreement between Enacon and the Ministry of Defense, subject to the terms of this agreement, unless this arrangement is terminated earlier by Namcor Trading for whatsoever reason.
Mr. Inambao, did you ever read this paragraph? When
I
you spoke
did.
to the, did you tell the prosecutor, alert the prosecutors of this paragraph?
Your Worship, actually what this paragraph,
No. Answer the, I'm not saying interpret the paragraph. I'm saying, did you alert them of the paragraph? Answer the question.
Your Worship, the evidence was gathered. The prerogative of the questions that the prosecution would ask when they are in the court, it is theirs.
Okay.
My duty as an investigator is to gather evidence and present it to the prosecution team.
Okay, good. Now, let me break it up a little bit. These paragraphs, and I'm not interpreting anything, it says, following, that it means after, the transfer of ownership of asset to Namcor Trading, pursuant to this agreement, in other words, the asset agreement, Namcor Trading hereby authorizes Enacon to utilize and store only petroleum products for the duration of supply agreement between Enacon and Ministry of Defense. Now, here comes the comment. It appears, as Mr. Murunga confirmed in his evidence, Enacon was not going to walk away. It will continue supplying, but exclusively buying products from Namcor. Any comment? Only if you have a comment.
Your Worship, and I agree with you.
Oh,
But what this paragraph also says is the assets where the owners of the assets was Namcor Trading.
yes,
But
we are together. But they authorizes my.
Your Worship, I think can the witness
Finish.
be allowed to
Okay,
finish?
no, it's fine.
Your Worship, and I'm answering this question based on the previous statement which I was made to read, Your Worship.
no.
Just answer the
Yes.
Just answer the
we are-
question.
Yes, where
Your Worship, I think I have
Yes,
to.
Mr. Namanja, please can you let the witness? Yes.
I also have to bring to the attention of the court that the witness is not here to interpret the contracts, and we are not at trial now. And I think it's totally unfair to confine a witness to a certain paragraph, and if he wants to qualify a question, then he's precluded that you cannot answer that question. That's not what I'm asking you. Because if he's asking him to interpret, and that's
I'm
what
not
he's referring him to specific terms that please confine yourself to this. And if a witness wants to refer to another paragraph which actually wants to confirm or to comment what he's asking him, I think he should be allowed to make context to the question and not just to confine him. And that's why aspersions are being casted that the prosecutors didn't do this, because they want to corner the witness to a specific aspect, which is totally unfair.
Your Worship, may I just remind the court? You will remember, Your Worship, that I raised an objection about content. You will remember, Your Worship, that my learned friend took our affidavit, read only parts he wanted, confined the witness only to parts he wanted. When we raised this issue, we were told that is all I want. So, Your Worship, in the same manner, and of course this court ruled against us, surely this objection should be overruled on that concept.
And Your Worship, I'm not asking. I said the function to interpret is with God. All I was saying to the witness, we are together that the asset became that of Namcor because of the asset agreement. All what I was saying, the agreement says then, after that, Namcor authorizes Enecon to utilize. That's all I was, and say, do you have any comment? Simple
Yes,
as that.
I am in agreement that you have put on record that you are not asking the witness to interpret the
Exactly.
contract. You are just asking him to comment.
Exactly.
Yes. So say,
Your Worship, can we get a ruling on the objection?
yes, the objection, it's already been stated that the witness is simply been asked only to comment, not to interpret.
Exactly.
Yes.
Yes.
Then for that reason, the objection is overruled.
Thanks, Your Worship. We are indebted to court. I want to move fast, sir. Are you still at page 55?
I don't think I've provided you an answer.
Okay,
Or,
okay. Mr. Inambawa, do you want to finish?
Because before he responded or while he was
Yeah.
busy, he rose for that objection.
Okay, can I just repeat it? Just
Sure.
leave other pages so that we move on. All right, I was trying to say, do you see that Namcor, according to the agreement, once the agreement is signed, was going to authorize Enecon to use the same assets?
that's right.
Okay, let's move on. Go to 3.3. Read it out.
Enacon undertakes to procure and ensure that only those oil/petroleum products as supplied by Namcor Trading are to be stored, handled, used, dealt, or distributed in, through, or from the assets. And the assets shall not be used for any other purpose or in any other manner whatsoever.
Yes, this is exactly what Mr. Murunga testified, that as Enecon get authorized to use those assets acquired or bought by Namcor, it must only use to store products acquired or bought from Namcor Trading. Any comment?
No. I'm happy, Mr. Namanje, because you are confirming that Namcor actually bought the assets,
Yes.
and not the rights and titles.
It's the same.
Yes, we can move on.
Yeah, yes.
That issue we have already
Exactly.
discussed. Yes.
So you are agreeing with this?
Yes, that Namcor was buying assets.
No, that's not what I'm talking about.
Yes.
I think you misunderstand. Are you listening to
You still want to go back to the question, or?
Because you don't understand.
No, Mr. Namanja, we can proceed.
Okay, but I want to confirm because there is a secondary question. But you have no quarrel with this statement?
Yes.
Okay, very good. But this statement contradicts what was put to my clients by the public prosecutors. They were saying, you sold a dream, you continue, in fact, my clients were pressed, you continue supplying petroleum products, and Namcor did not take over the asset, did not get ownership of the asset. This statement, you agree with, contradict what was put to my clients. Why do we have these contradictions?
I agree with the statement, Your Worship, 100%.
Okay.
And in order for me to qualify that statement, it begs a question as to why would Namcor, after already having entered in a fuel supply with Enacon on the 16th of March, buy assets and not use them at all?
Oh,
so why
are you asking me a question, sir?
Unfortunately, you cannot put a question to counsel. You can just answer the question.
It was not a question, Your Worship. I was just...
No.
Okay.
That's why I'm saying, do you trust Namcor, the complainant?
That question has already been asked.
Yes.
Can we move on? Yes.
Can you then go again to, I'm trying to expose the contradiction between your investigation and what was put to my client. 3.4, can you read 3.4 and 3.41? Start with 3.4, page 55.
3.41. Must I start there?
Yes. Start with 3.4.
Enacon shall not use or permit the use of the assets otherwise than in connection with oil petroleum products supplied by Namcor Trading.
Okay, just hang on there. This is Namcor cementing or confirming exclusivity, that in those tanks, it must only be products bought by Enacon from Namcor. Do you agree with me?
That's what the term is saying.
And just for your information, this is exactly what Mr. Murunga testified. Any comment? This is exactly what Mr. Murunga testified in this court.
I was not there when Mr. Mulunga was testifying.
Okay.
He may have as well done that.
Okay, let's go to page 56. Can you read 3.5?
Namcor Trading shall be entitled from time to time to affix, paint, show, display, and exhibit advertising and other signs on or to the assets as it deems fit.
Yeah, just end there. Did you find any evidence of my clients prohibiting or impeding Namcor to put up adverts on those home-based stations?
No, Your Worship. We also must not lose sight at the same time when Enacon had entered into this agreement with Namcor. They had an agreement, a standing agreement with NDF.
No, I'm trying to say, did you gather any evidence where my client impeded, prohibited Namcor as entitled to put up advert for their name on those stations? Okay. And can you then read again 3.6 contradicts what was put to my clients by the Council for the State? Read it out.
Namcor Trading shall remain owner of the assets, notwithstanding the manner of installation, and Enacon shall not pledge, hypothecate, sell, or dispose of the asset nor cedes its rights thereto without the prior written consent of Namcor Trading.
Paragraph that says Namcor bought asset but authorized Enecon to use them for product bought, and then this paragraph then protects Namcor's right so that the assets are not sold. Do you agree with me?
These assets are assets of NDF.
Oh, okay. Oh, I just want to park it there because I will be taking you to something that contradicts all that for you. But are you still talking about pumps, canopies, and tanks?
Your Worship, the annexure B that is being referred to lists all the
Yes.
items that are referred here to.
Okay, and those are movable assets.
The tanks,
Yes, tanks is a movable thing.
some of them are under the ground.
Even when they're under the think.
Not to think, because Enacon at the same time had an
Point 2, I just want to read it out because you read it, Your Worship, you read it from 3.4. Enecon shall not, then 3.42, reposition, move, or remove the asset in a manner whatsoever without the written consent of Namcor Trading. Do you have any evidence of Enecon after the agreement removing or repositioning those tanks, pipes, and so forth?
no.
Just pick up.
No.
Okay. Then move to page 57. Paragraph 4.3 is, of course, Enecon indemnifying Namcor Trading. You see that?
57, which paragraph?
4.3.
4.3.
Yes, I want to move fast. That it's Enecon undertaking to indemnify Namcor Trading.
Yes, no, I'm there. I thought you were busy reading it.
Yes. You confirm. I just want you to confirm.
Yeah, yes.
Okay. Now, and then look at 5. It's then said, if you can just read it out, I will say stop.
Namcor Trading has the right at its discretion to terminate the agreement relating to Enacon utilizing Namcor Trading's assets by giving Enacon 1 month written notice.
Okay. So remember, what agreement is being, if you understand, I'm not asking you to interpret. If you cannot, please just say. What agreement is being spoken about in this paragraph?
It's the one we are busy reading. The asset purchase agreement.
No. But it's a sub-agreement of utilization of the asset. Am I not correct?
But it's contained in the same.
Yeah, exactly.
Yes.
That's why I say sub-agreement. I think that this is where, with respect, you misunderstood this case. Asset purchase agreement gives the right of ownership to Namcor Trading. That is the main agreement. Within that agreement, Enecon utilizes the assets.
The assets which are also at the same time intended to be properties of the NDF.
Nobody says that. We'll go that. So this utilization is about the asset acquired by Namcor. You agree with me?
Yes.
Okay, very good. Now, then you have been in the charge sheet. Is it you that suggested to the state that the agreement relates to 9 service stations? Or it was not you? Who introduced the term service stations? Do you know where it originated? How did it find itself in the charge sheet? Who?
I don't know how it found itself on the charge sheet, but it's a term that an ordinary person uses when it comes to a filling station. So I could have as well used it in my statement. So,
but did you find the law applicable to service station? What law is that? Is it not the Petroleum Product and Energy Act?
Yes.
13 of 1990.
Yes.
Have you ever read that act?
I have. To
Okay,
some
you
extent.
read it?
Yes, I have, especially when it comes to the licensing.
Okay. Did you also read the regulations made by the minister in terms of section 23 of that act?
No, I haven't read the regulations.
Have you not read the regulation? I assumed you did.
No, I didn't.
How do you investigate this matter without
Your
reading?
Worship, it's an objection. What relevance is that to the regulations of this witness reading the regulations in the Petroleum Act? I do not think it's relevant, Your Worship, for the issues that we assist with. In fact, it has been said that time consuming when I was going through the bank statements. So I believe it's also time consuming to bother this witness with issues that are totally irrelevant.
Highly relevant because I will then be able to demonstrate these loose words being thrown that NDF, Ministry of Defense, owned assets and that my client sold assets that do not belong to Enecon. So
you have asked the witness whether he read. He said he did not read the document.
But I'm still entitled to go and inform him. The only reason why I asked whether he read is for me to assist him and take him to the regulation. Yes.
In fact, the record will reflect, Bishop, that there were suggestions made by the state that this Enecon, EcoFuel, and so on, Your Worship, did not even have licenses to supply fuel. So it is highly relevant, Your Worship.
Highly relevant. I'm also demonstrating that this service station is an alien animal. We don't know such kind of things in Namibia. Can I proceed, Your Worship?
We can.
May I?
However, as I indicated, this is a bail application. We must confine ourselves to issues which are relevant for the bail application.
Your Worship, you will see that I will go to the end. I made a number of objections. Then I was told, fine, it's a bail application. It's on record. I must I will go to the most relevant thing. I will not.
That is what I'm saying.
Okay.
Remember, we had your colleague there, just for the record,
Okay.
Mr. Bangamamwa. He went on when he was leading about the matter at the Labor Court, and you are the one who rose up. That issue has nothing to do with. I'm just trying to remind you that can we focus on the issues before court?
No, it is definitely, in fact, it is at the center of the court, what I'm going to deal with.
Yes, so can you confine yourself to those issues which
as the court
will assist the court in
Yes.
dealing with?
Can you hand up the bundles, please? and give one to the witness. And Your Worship, I have given my colleagues copies, enough copies. Do you have the copy of the regulations, Mr. Inambao, in front of you?
Yes.
I have numbered them from page 1 to page 97. There is one judgment attached, but the regulation goes up to page 79, 80, Your Worship. Now, I will move fast. I want you to go directly to page 6. Definition section. And Mr. Inambao, I remember I spoke about service stations, and there was assets spoken about, which I said they are movable. Okay, now let's just deal with certain definition, and I will ask you a few questions before we go to some section. Can you read the third definition?
Is it the licensed premises?
Yes.
Means the premises in respect of which a retail license is granted and which premises are described and specified in the retail license.
Okay. Now, physically, if you have tanks, some may be in the ground, some may be off the ground. A premises will always be there, land for it. Do you agree with me?
Yes.
Okay. It's not disputed that the tanks and pumps are at the premises or land owned by the Ministry of Defense. That is not disputed.
It's not disputed.
Okay. And it's also not disputed that what was sold to Namcor, it's not the Ministry of Defense land. Do you
No.
agree with me?
Yes, I agree with you.
Okay. But you are aware that land is transferred through the office of the Registrar of Deeds, and there must be a title, a document that is called a title deed.
That's correct.
Okay. Then we move down to an operator. Can you just read out? Mr. Murunga testified about an operator. It's very important, Your Worship. Read the definition of an operator.
Means a person who is responsible for the day-to-day activities of a retail outlet or consumer installation where or not the person is located on the relevant premises during business hours, and whether or not the person is the owner of the retail outlet or consumer installation, and in the case of a retail outlet, if such activities are for on profit or loss.
Okay, in respect of those assets, the outlet that were there, the dispensing of petrol products to Ministry of Defense, Enacon was the operator. It had a retail license in respect of those home-based stations. Enacon was for its own profit.
Yes.
Okay, very good. Then, at page 7, Your Worship, page 7, Your Worship. The retail license that we spoke about, which obviously you can check at the ministry, which it's common cause, Enacon has, is then stated in the middle. You see the retail license definition there, which are granted under section Regulation 5. You see
Means a license issued in terms of Regulation 5.
Yes. Yes. And now, can you then this is the very important, the fourth line from the bottom. Can you just read it out?
Storage tank means a closed container that is used for the storing of petroleum products.
Okay. That is a movable. This something that is defined here is a movable asset, property. Do you
Yes.
agree with me?
I agree with you.
Okay. it does not get transferred through the registrar of deed at the Ministry of Land.
Of course, it doesn't.
Okay. So there is no title deed, like in respect of land.
There is no title deed, but your client signed a contract which is referring to a title as well.
Now, it referred to a title, not to a title deed. You must listen, sir. You must listen. Go to page 8. You see at the bottom section, this is very important. Number 3. Read number 3, Roman subsection 1 and A. Can you just read it? 3.1a.
3.1a.
Yes.
Operate a retail outlet or...
No. Page 8, regulation 3.1a, starting with no person shall.
No person shall
Yes.
operate a retail outlet or conduct the business of a wholesaler unless authorized to do so under a retail license or a wholesale license.
Okay, let's just end there. You considered yesterday that the Ministry of Defense, according to that agreement between ENECON and Ministry of Defense, it is ENECON who must have all the required licenses to operate an outlet. It's not the Ministry of Defense.
I didn't concede. That's what was contained in the agreement.
Yes.
Yes, so that was not me conceding.
You agreed with me that
yes,
the agreement says
at least that's the way that you are supposed to use that agreement.
No, it's fine, the same thing. So all I'm trying to say, the party that have their statutory right, commercial right to operate an outlet in accordance with this regulation was not the Ministry of Defense, but ENECON.
You are right, and I don't know why we are going there because that has not been disputed.
No, lawyers, we know why I'm there. Just answer questions.
It's already been answered. Can we move on?
Then, page 9. Page 9. Now, I want to skip that for a moment. Do you agree that in respect of an operator like ENECON, the obligation to have necessary permission for environmental protection purposes, it's again ENECON in this context?
That's right.
Okay, not the ministry.
Yes.
Okay. Then move to page 12 with speed, please. Those under section regulation 7, it provides for conditions of a retail license. You see that from 7.1a to H. You see that?
I'm there.
I'm saying, do you
I
see?
am there.
Okay. Then move to page 26. Yes. Can you read regulation 30, subsection 1b? Yes.
31B. Are you sure it's 31B or 2B?
2b, yes, 2b. Thanks, Mr. Inamba.
If any such change of information relates to
Then B.
B, in the case of a retail license, to a change in the name of the operator, the records required in terms of regulation 4.2 shall be supplied with regard to the proposed new operator, and the proposed new operator shall complete Form PP1 as set out in Annexure B, in as far as it is applicable, together with the application for the amendment.
Okay, why I'm asking this, Mr. Murunga testified that, and he gave example at Husab Mine and other examples, that an operator, when you have installed and invested in assets, such as an outlet, if there is another operator coming, and that operator will not have such right unless there is an agreement with the original operator. You acquire the asset, and obviously you have to get proper licenses to take over the asset. Do you have any comments?
No comment.
So in other words, what I'm trying to put it to you, this asset, this infrastructure, at all relevant time for the next 10 years, that the supply agreement was, the 10-year supply agreement was in force between Namcor and Enecon. They at all time owned by Enecon.
You mean Namcor?
Can you just repeat the question?
From the date of the sale of the agreement, sale of asset agreement, the asset that were owned by Enecon, in accordance with the asset agreement, will be owned by Namcor, according to the agreement.
According to the agreement,
Yes.
that was supposed to be the case.
Yes, it is the case. Let's then move to page 35. Speaking about storage tanks, you see that that is a section we debated about, where I made a comment to you that tanks are not immovable assets or properties. Remember?
Yeah.
Now, can you just read out the those two paragraphs at section 46? In this context, it's very important why I'm asking that question. Just read them out.
This regulation applies.
Applies.
And that's what I said, applies.
Okay.
With an S.
Okay.
In the case of an above ground storage tank, to a storage tank in a capacity of 2,200 liters or more, and in the case of I think it was supposed to be a below ground, but it's written a case of an below ground storage tank, to a storage tank with a capacity of 4,500 liters or more. 2, every license holder or certificate holder shall, with regards to any replacement or installation of a storage tank or a remaining storage tank to which this regulation applies and which is in the possession of such license holder or certificate holder, annually, not later than 28 February, duly complete Form PP10 as set out in Annexure B, and shall submit such together with information requested therein to the minister.
Yes. Now, in relation to this matter, did you investigate who have the required certification in relation to those things?
There was no need for us to go to investigate the tanks at the Ministry of Defense.
Yes.
As we went to the Ministry of Mines and Energy to try and find out as far as the registration and the licensing, and that we were given.
Okay.
Yes. And hence, during the investigations, it was established that yes, Enacon, Erongo, Ecofuel had the necessary registration and certificates.
Including certification for tanks.
That's right.
And those tanks are the subject of the sale between Namcor and Namcor.
Must I comment?
Yes.
The Ministry of Defense cancelled the contract of, the agreement between Enacon and the ministry last year in 2024.
Yep. That is not what I'm asking.
Yes, and we are talking about the ownership. So, and I'm just trying to ascertain, or rather, I'm trying to provide information that
Okay.
when, for example, the ministry cancelled this contract, the remainder, Enacon had claimed from the ministry the remainder of the 10 years.
Yeah, exactly.
Then that should...
It's entitled according to the agreement.
No. If the assets is for Namcor, then it's Namcor which is entitled to claim that money.
No. But didn't Namcor cancel the agreement? Mr. Ndeunyeme.
That was before. I cannot comment on the date, but...
No, 2023.
We can leave it at that.
Why did you go there?
No, because if Namcor was the owner of these assets from 2022 until 2023,
yes,
they were entitled to a part of that.
Yeah, but are you their debt collector?
No.
Okay, so leave it. So now, at page 74, page 74, same document. Do you know that document in terms of Regulation 46? Just to be fair to you, Regulation 46 is the one that deals with the tanks.
I don't know the document, but this is a document that we have been referring to when we have been reading here from PPT 10.
Okay, yeah, exactly. And that is the annual document that you give to the Ministry of Mines if you are the owner of tanks. You give information. If you look at the bottom, A, can you just read out the information necessary annually from A to G? Just read it out, please.
The name and address of the owner of the storage tank, the type of the storage, the location of the storage tank, unless it is not intended to be in one place for more than 6 months, whereupon the storage tank must be indicated as having multiple temporary unspecified locations. The storage capacity of the storage tank, the type of materials used to manufacture the storage tank, the year manufacture of the storage tank, the year of the storage tank's installation, if available.
Very good. Now, let's then end with matters of your objection to bail. And let me just see with my colleague. Okay, now let's first start with the allegations of abuse of power in the process. Remember, I said that it appears you come to court with dirty hands. Remember, I said that.
You may have said it, okay, but not to me.
Okay. Are you aware that during the arrest, cell phone device was taken from Lydia Elindi by Inspector Anna?
That's correct.
Do you know why it was taken?
Your Worship, the cell phone devices were taken because when we arrested accused number 1, Mr. Velemse, we realized that...
Number 1 is Murunga.
Accused number 2.
Yes.
We realized that he had made phone calls and it was possible, and therefore we believe that it's possible that information could have exchanged with other suspects. Because as we were there, he started receiving messages, he started receiving phone calls from various individuals who are part of the suspects that we were still looking at that point in time.
Okay, fine. When did you realize that? My client, Lydia Elindi, was arrested on the 8th of July. When did you realize that? 9. Yes. Sorry, Your Worship.
Yes, Your Worship, that was on the 8th.
So that in relation to Mr. accused number 2.
Yes, that was in respect to accused number 2.
On the 8th.
Yes, on the 8th.
And that has nothing to do with Lydia Elindi.
Yes, Your Worship, we arrested Lydia on the 9th.
Okay, no. Whatever happened on the 8th in relation to the information you have has nothing to do with Lydia Elindi. Is that correct?
That's correct.
Okay. Then, so you when did you decide as a group that Lydia Elindi's phone will be taken and that of the other clients of mine?
Your Worship, we were waking through the night, looking for other suspects. In fact, Your Worship, by the time we finished that first day, I believe it was late in the night.
Yes. I'm asking, can you answer the question, when did you decide phones must be taken from my clients?
Your Worship, I suppose this was decided upon when we arrested the individuals.
You are saying supposed. You are the investigating officer. You must know, sir.
Your Worship, there was no time to go and look for the search warrant. As I'm saying, from the 8th when we arrested accused number 2, we worked through the night.
Yes.
Therefore, Your Worship, there was no time for us now to go and look for the search warrant to go and search.
Who spoke about the search warrant now?
I'm just trying to put the ground as to why there was no time for us to go and.
But you do not know when the decision was made to take the phones.
Your Worship, as I said, at the point we arrested accused number 2.
Okay. Was that the point? You took it instantly when you were arresting accused number 2, you say?
That's correct.
You took a general and indiscriminate decision that you will be taking everyone's cell phone.
Our plan, Your Worship, was to arrest everyone on that day if it was possible. But unfortunately, because of the time, we had to proceed through to the next day.
But the warrant of search against my clients, in particular Peter and Marakia, were obtained, signed by the magistrate already on the 3rd of July. Am I wrong?
Oh.
Your Worship, if you can look at the...
You mean the warrant of arrest?
Yes.
That's correct?
It's correct. So a period of 6 days passed after the issuance of the warrant without urgency and speed to arrest.
We did not obtain search warrants for the residence. Remember, we arrested you.
Yes?
We didn't obtain a search warrant for the residence of Mr.
Oh, I'm talking about warrant of arrest, if I refer
Yes.
to...
So initially,
Yes.
we were not going to take the cell phones.
Initially.
Yes, we were not going to seize anything because we were not having the search warrants.
Okay.
But upon apprehending accused number 2,
On the 8th.
on the 8th,
Yes.
we realized that there were messages because he had locked himself in the room before we arrested him.
Okay.
So at that point, a lot of information could have been.
Okay. What time did you arrest accused number 2 on the 8th? a day before my clients were arrested?
I believe that was around 11 or so.
Okay. And you were a group, a huge group, it appears.
Not a huge group.
Okay.
We were a group.
Yes, yes.
But not a huge group.
Did any one of you go and obtain, after you then decided on the 8th, you will have to take cell phone? Did anyone go and attend to the application for a warrant of search and to seize my client's phones the next day?
No, Your Worship.
Okay. Then you just decided to go and take the phones without judicial authority?
Not without judicial authority. We believed the phones could have been used to exchange some vital, critical information.
Okay. What is the default position in Namibia in respect of seizing somebody's property? What is the default ordinary position, constitutional position? What is the default requirement?
You must believe the object was or is used in the commission or, to store evidence.
Yes, but in relation to authority, what is the default requirement?
Seized with or without a warrant.
No. Have you ever read Article 13(2) A and B of the Namibian Constitution?
You can just, try to explain what is it that you want me to get at.
It says that all searches must be through, in accord, on the basis of a judicial authority, unless then there are exceptions. So the default and primary requirement is the judicial authority. Do you know that?
Of course.
Okay. So it appeared to have been your deliberate decision not to obtain a judicial authority.
Your Worship,
you could if you wanted, because you were so many. On the 8th already you could have obtained a warrant of search.
We were time constrained and we worked through that night, I believe, until late at night.
Okay. I want to put it to you, you deliberately approach the matter on the basis that you will not go and apply for the search warrant, you will just grab and take those phones. I put it to you, and that is what I am going to argue.
No comment.
Now, the password of Lydia Erindi was, by force, was taken, and also I think accused number 4. Why was it taken?
The rationalization for taking the phone was to use them as evidence, so that to have them forensically examined to see if there was an exchange of information between accused number 2 that was arrested with any of the accused.
Oh, so it was to intrude without a warrant in the data and content of the phone.
It was to get evidence from there.
What about her conversation with the husband? What would have happened to them?
What would have happened to them?
Yes.
Your Worship.
What protects them?
Evidence, Your Worship, would have related to, if, for example, Your Worship, there was no communication between between her.
Look,
Mr. Ramanje, the court, before you proceed, the court will take a 15 minutes.
That's the court.
Court adjourned.
Please, the court.